Hi, good afternoon. I'm talking to you all today on Friday, August 2nd. I wanted to make this video for you guys because some of you may know this, but some of you may not know that I'm going to be going on vacation starting tomorrow, August 3rd, for 2 weeks to Europe. Yay, me, right? And with my family. And so I wanted to leave you all as prepared as possible for the parole in place program. I know how important it is to so many of you guys. And we want you to be able to start collecting documents, get yourself oriented as much as you can for the process so that when I am back in the office, coincidentally on Monday, August 19th, when the program first gets implemented, that we will be all ready to go. Now, this video is going to talk about what we do and do not know about the program and just some practical matters that I wanted to discuss with you all so that we can get your cases processed and filed as quickly as possible, right? So this video is going to be about the spousal parole in place program, the program that was announced on June 16th, 2024 by the Biden administration to allow people who are married to US citizens as of June 17th, 2024, to be able to apply for something we call parole in place, right? So what is a parole in place? Parole in place is basically an entry document given to you while you're already in the United States. And there's already mechanisms in place for parole in place requests, which are mostly done for family members of US military service members, right? So like if my adult child is a US citizen service member, or my spouse is a US citizen soldier, there's already been a mechanism in place to get a parole in place to cure unlawful entry. And that's the idea of the parole in place program, is to cure an unlawful entry. Instead of having an unlawful entry, you now have been paroled into the United States. And that is one of the main requirements for adjustment of status, for being able to do your green card within the United States, right? You have to be inspected, admitted, or paroled is the language we use, right? So everyone's going to fall now into, if they get accepted into the parole program, they get a parole approved, will fall into that last factor prong for eligibility for adjustment of status in the US, being paroled, right? And of course, that means amazingly that people will be able to avoid the whole I-601A waiver process and the risks, although small, associated with leaving the United States and going to the foreign or well, the US embassy in your foreign country and then coming back with your green card. We can eliminate that whole process if we obtain a parole in place. So that's why this program is so huge. It will take everybody out of that I-601A waiver line, which also, as many of you know, because you're in that line right now, it's about a 4-year adjudication time for an I-601 waiver. And so this will get people out of that long line, allow them to do their whole green cards in the United States, right? So I'm going to put on the screen now the eligibility requirements, right? So we can just go over basic eligibility. And I've been telling people, if you meet these basic eligibility requirements and you don't have any disqualifications, which I'm going to discuss at the end, then we really don't need to have a new consult about this or anything like that. We just want to get working on August 19th on these files, right? So pretty much everybody who has an I-601A waiver pending right now, except for the ones that have removal orders, will qualify for this program, right? So if you have an I-601A pending in our office, we absolutely want to switch you to parole in place. If possible, we want to do it and be able to do your green card in the United States, right? And it's going to be such a gift to you and your US citizen spouse, right? So let me put this on the screen now. Oh, let me just say, this video is going to be kind of long, guys, so just bear with me. I want to go through as much details as we know right now. We are still waiting for the actual publication of this regulation in the Federal Register, right? And that's how rules, official rules, regulations are promulgated, right? That goes through a process under the Administrative Procedures Act and becomes law once it's published in the Federal Register. Now, lawyers and other people have been complaining that to date, and like I said, this video is being recorded August 2nd, 2024, there has been no publication in the Federal Register, right? Now, I am of the opinion, because I used to do a lot of in federal court litigation on immigration matters. So I am a litigator, right? Not every immigration attorney is a litigator as well. But I've filed many complaints under the Administrative Procedures Act. I know a little bit more about than the average immigration lawyer, let's say, about how that works. And usually there is a 60-day public notice period for a new regulation, right? So it makes sense, like the August 19th date is not random. This was announced on June 16th, and the 60 days would be August 16th or 17th, but that is the weekend, right? So then it gets moved to Monday, August 19th. So the government is following all of the what we call rulemaking procedure under the Administrative Procedures Act. This is super important because one of the issues with, for example, DACA, Deferred Action for Childhood Arrivals, which is at a standstill right now. There was supposed to be a program called DAPA, which was Deferred Action for Parents of small U.S. citizen children, right? Those programs have been subject to a lot of challenges in litigation in federal court. And part of that reason is because they were executive orders. They were not regulations published pursuant to the Administrative Procedures Act in the Federal Register, right? TPS, for example, is a rule published in the Federal Register, right? And that's what makes TPS. That's what makes it hard, for example, when like a new president comes into power, they can't just like rip TPS away from a country because it is in the Federal Register. It's gone through a rulemaking process. And yes, it can be repealed. Any law can be repealed, of course, but it has to go through very specific procedures to be repealed, right? And so that is the main difference between this rule, and I'm calling it a rule because it is a rule, versus a executive order, okay? And so a lot of the things recently that we've seen under both the Biden administration and of course the Trump administration before that were executive orders that are easy to rescind, right? A new administration comes in and rescinds an executive order by their own executive order, right? And so this is being done in a different way, which should help shield it from a lot of court challenges, right? So that's a bit of question I've been getting. Like, do you think this is going to get challenged in court and thrown out in court? Do I think it may get challenged in court? Yes, of course, especially if Trump takes power in January next year after the November elections. But it will still be very hard, much harder to get rid of than, like I said, for example, something like DACA or that proposal for that program for parents of U.S. citizen children, right, who didn't have status, right? So with that kind of said, I'm going to jump into the basic eligibility requirements. And oh, excuse me, just one more thing. So like I said, I don't actually think it's going to get published until August 19th. And because of that, some of what I'm going to talk about later on is we still don't really know 100% who will be disqualified. Like I can tell you if you meet these basic requirements, you will qualify, right? But there are some gray areas that I'm going to talk about at the end of this video. And those are mainly for people. So if you are one of these people, please stay tuned till the end of the video. If you this does not apply to you, I'm going to tell you when you can turn off the video and you don't need to listen unless you just want to learn about it, right? Now, those are three categories of people. People with removal orders, people who have multiple illegal entries. They've not just entered the United States illegally once, they've entered the United States illegally more than one time, especially if they had 1 year of unlawful presence in the US before they re-entered or were deported before they re-entered illegally, right? And then the third one is people with certain criminal records, right? So we don't know yet exactly what the criminal disqualifiers will be. So if you just have traffic stuff, driving a driver's license, I'm not talking about you guys when I talk to criminal, I'm talking about things non-traffic related, except for DUIs. If you have a DUI, I'm not sure, okay? But I'm just talking about driving without a driver's license, driving without insurance, without a valid registration, speeding, like none of that. We've never actually had any immigration program that where those were disqualifiers. So I don't believe that you guys have to worry if you're just traffic offenses, okay? Now, And now I'm really gonna start. Okay, and I'm sorry. Like I said, this is gonna be long, but you guys know me. This is for you guys and my existing clients. It's not like a marketing video. And although feel free to share it with anybody you know that you think may qualify for the program. But this is really for you guys, my existing clients, and mainly because I'm going to be away for the next 2 weeks. I'm not going to be there to answer questions, and I want to kind of cover as much as I possibly can. And if you guys know me, which you all do, I am chatty and I am very thorough and comprehensive, right? That's why you guys love me. Maybe you hate me a little bit too because I talk too much, but mainly I think you guys love it. And I've been told so many times that compared to other immigration lawyers people have worked with in the past, just how much more comprehensive I am. So I'm gonna stick with that. That seems to be what you guys want and like, and I think that it's important to give you all the knowledge possible. And I always tell everyone, you guys are the best paralegals in your own case, right? Like you work with us. And we don't work for you, we work together, and we need to work together to make this happen quickly once the program opens on August 19th, right? Monday, August 19th. That's our special day. Okay. So now I'm going to put, I've been working on, and I'm going to email this, that all this is attached in the email that I just sent you with this video link, right? So you're going to have all this and you've got to start doing your homework, okay? So, all right, this is now on the screen. Okay, perfect. So, spousal parole in place program, right? I was saying August 19th, 2024, US will begin accepting applications. What we don't know the actual form, although I'm pretty sure I know what it is, because of a change in the USCIS fee schedule, which was published on July 31st. But I'm going to talk about that when I get to that part. I am speculating a little bit on the form and the USCIS payment, but we do know that they for sure are going to start accepting on August 19th. Right now, there's not even a filing address available. Like you don't know anything. Like we're probably not even going to know where to mail out the applications until August 19th, right? Which is why we can't really do that much pre-processing. We don't actually know the form. We don't know the address where to send them. We can do document collection, and I'm going to get to this part in a minute. You guys should be saving up your money so that you can hire us right away on August 19th. But other than kind of collecting your documents, getting them organized, and getting your money ready, there's not much we can do until August 19th, when I suspect it will actually be published in the Federal Register, and we will get the instructions on the form and where to file and the filing fee, right? Now, this is the most important. Eligibility. Now, this is a discretionary process, right? It is a case-by-case basis. So just because you meet these requirements does not guarantee that you will get this parole. I want to be very clear about this. They are going to make a decision on a case-by-case basis. And this is why we are taking this part very, very seriously, the discretionary aspect. We're not just sending, a marriage certificate with proof of the 10 years. We are making big evidentiary packages of why our clients merit as a matter of discretion, a grant of this parole, right? So we are making a big equities package for you guys to make sure that on a case-by-case basis, they want to approve your case, right? But there is no guarantee. It's discretionary, and whenever you have discretion, it is going to be subjective to the person looking at your application form, right? Now, I have two screens, so I'm looking a little bit on the other direction, it's just on my other screen, okay? Now, the first requirement is be present in the US without admission or parole. And I put here in capital letters, you cannot have entered with a visa. So I have some people that have I-618s pending because, for example, they entered on a fiance visa and never married that US citizen petitioner, or they entered on a C1D1 crewman visa, which is just barred from adjustment in the US. And they have to do I-601A waivers. Unfortunately, you guys, because you entered with visas, you are not going to qualify for this program. You have to have entered without a visa, without admission or parole, right? I do have some clients out there who have not been able to prove that they entered with admission or parole. I'm going to say you guys should try. If USCIS doesn't believe that you entered with a visa, why not benefit from this program, right? And so I do think it's a little gray area. Obviously, if we argued in the past that you did enter with a visa or not a visa admission, right, like through the border, waived in, or with a visa now it's lost. Obviously, I think USS could come back and say, listen, you previously said you entered with admission. Now you're saying no, but I think it's worth taking a chance on, right? Now, This one's obviously a black and white requirement. You have to have been continuously present in the US for at least 10 years as of June 17, 2024. So when we're talking about our 10-year evidence, I need you guys to be going back from June 2024 to June 2014 at least. Remember, everyone here entered without inspection, so USCIS has no idea when you came. So this is going to be a big burden, what we call burden of proof for us to meet our burden of proof that you actually have been here for the past 10 years before the program was instituted. Now, or announced, let's say. Have a legally valid marriage to a U.S. citizen as of June 17, 2024. So we're going to pick apart the sentence. Legally valid means that divorces had to be done. You can, this is a proper valid marriage that occurred before June 17, 2024. I think if you got married on June 17th, you're not going to qualify. It had to be June 16, 2024 or before, okay? That person had to be a U.S. citizen before June 17, 2024. So if your spouse naturalized on June 18, 2024 and became a U.S. citizen, you were not in a legally valid marriage to a U.S. citizen on June 17, 2024, okay? Now, these are kind of the ones we don't know yet. This should be detailed when we get the Federal Register. It's going to be much more detailed, right? And it's going to tell us, and the instructions are going to tell us, we just don't have this information. Not have any disqualifying criminal history, otherwise constitute a threat to national security or public safety. Those ones I think are just general catch-alls, but disqualifying criminal history, we will not know what that is until we get the actual publication of the rule, likely only on August 19th. Now, something like TPS is pretty generous. Like you can usually have 2 misdemeanors, and as long as you don't have a felony, you're fine, right? So I think even one small misdemeanor probably will not affect you. But again, I'm speculating. I do not know. We have to wait for it to be published, right? Now, otherwise merit a favorable exercise of discretion. And this is where I'm talking about that we are taking this part seriously and putting a full equities package together, showing that you all are awesome people. I do have the best clients in the world. So this part shouldn't be that hard for you guys, but we want to be able to show that you merit a favorable exercise of discretion. And of course, we will include some of the hardship elements to your U.S. citizen spouse in that discretionary analysis, right? There's also, it's not listed here, but there's also a part where they wrote otherwise eligible to adjust status. Like meaning that if you cured the unlawful entry, that you could otherwise be eligible to adjust status. So I'm going to assume, and again, we don't have the final rule yet, these are assumptions, that if you are inadmissible on another ground, fraud, your criminal background, it's a misdemeanor, but it's also an inadmissible misdemeanor ground. Like easy one is a simple possession of marijuana. That's a ground of inadmissibility, even though in most states it can be a misdemeanor. In some states, it may even be like a ticket, right? Like a citation. It doesn't matter. It's a inadmissible criminal offense, right? So you're not otherwise eligible for adjustment of status. You would need an I-601A waiver. That's another reason why maybe the permanent people that are subject to the permanent bar from multiple illegal entries in the U.S. may not be able to do this program either, because they're not otherwise admissible. They're still inadmissible under that what we call permanent bar for multiple illegal reentries. And there is a wording in the USCIS publication that says you have to be otherwise eligible for adjustment of status, right? So keep that in mind, right? Now, I'm going to put this back on the screen. If you meet these requirements, if you meet these basic requirements, you only entered the US once, you don't have anything beyond just basic traffic offenses, or hopefully no criminal record at all. You were married to your US citizen spouse before June 17, 2024. You've been here since at least June 2014, right? Before June 2014, then you should be fine, right? And let's go ahead, assume you're going to apply. You should do it, right? Okay. These are just my warnings, like I was talking about, unclear whether people in removal proceedings or existing removal orders can apply for the parole in place program, unclear what type of criminal records will disqualify, and also unclear whether or not people in multiple legal entries will qualify, right? Now, this is probably the important part for you guys, costs, right? We still don't know what the application forms look like, so this could be subject to change, but I'm going to try to stick with this, guys, right? So you guys know. The cost is going to be $3,000 in legal fees. Like I said, we're going to put together these equity packages. do the application forms. And unfortunately, I know you guys are going to ask me about this. Are we going to do payment plans? We are not going to do payment plans on this, guys. And I believe that the filing fee for USCIS will be $630 on a form I-131, but again, I don't actually know that 100%. That's an estimate because they have not actually published that information yet. I don't believe we'll know until August 19th. Now, I'm very practical. I'm always very honest with you guys, and I want to talk about the fee and why we're not doing payment plans, okay? Because I know that that's going to hurt some of y'all. But if you need to borrow money, if you need to max out a credit card, honestly, this should be the most important thing in your life, right? And if I told you that your air conditioning was broken and you needed $3,000 for a new air conditioning unit, you would find it because most of you guys are in Florida and you're not going to live without air conditioning, right? And so I know that when people need to get money together, they can, okay? And this needs to be your priority because obviously we want to try to get the cases in early. You know, I would say if they open on August 19th, I'd love to have a majority of you guys filed if I can before the end of August. And because of that, I am going to, as soon as I get back to the office on August 19th, kind of push aside all my other case matters. You know, if someone needs to do a work visa, unless obviously someone has a deadline, right? Obviously, I can't push away a deadline. But if it's not a deadline, someone's visa is not expiring, they don't have a deadline on a request for evidence letter, I am going to push their cases to the side to focus on you guys, okay? Because I know how important this program is to you guys. I know that we want to get kind of towards the front of the line because in the original announcements that I've been sending to you guys, they estimate there could be 500,000 people who qualify under this rule. And I don't want you to be sitting in a line. Like the whole point is to get out of the 4-year I-618 line, right? I don't want you guys to get into a line that takes years to process because out of that 500,000, you are, you know, number 350,000 who applied, right? I want us to be in the first, you know, I'm going to be conservative, like the first 50,000 to apply, right? Okay, we want to be kind of on the front end of that. Now we can only do so much to do that since we don't even know where to file or the form or anything like that till August 19th. But we want to try to get as much documents as we can together so that we can kind of execute this the week of August 19th as quickly as possible. And because of that, like I said, we're not offering a payment plan. We will need that payment in full because we are going to push everything else aside and we are going to prioritize your cases, okay? And then when we're ready to file it, you'll need that other $630 for the government. So please be budgeting for, you know, about $3,700 to do this entire process. And we're going to try to do it quickly, okay? So for the next 2 weeks, this is something you guys should be thinking about. How am I going to get that money ready, okay? Because you don't want to be left behind and you want to be, you know, like I said, at the end of that line, if they really do have, you know, 500,000 people applying for this new program, right? Because you know how USCIS works. Are they going to have a whole new department to do this? Are they planning for this 500,000 new flipping filings to come in? I doubt it. I mean, hopefully, guys, fingers crossed. But if you all have gone this far with me, you know USCIS is not run very well. Okay, so we need to anticipate that we want to try to be one of the first ones. And I'll give an example. When TPS opened for Venezuela, and there were hundreds of thousands of Venezuelans in the U.S., the initial TPS applications, and I filed like right away, like within the first week of eligibility opening, and some of those first applications took like a year to a year and a half to go through because they were just so overwhelmed with the mass amount of TPS filings for Venezuela that it took a year and a half to issue the first round of TPS to Venezuela, right? So I'm hoping that's not going to happen, but keep your expectations low, guys, that we could be waiting a long time for these paroles to be decided. Hopefully USCIS is making a plan for how to accept all of these applications and adjudicate them, but as you all know, that may be very hopeful optimism on my part, right? So, okay, now I'm going to put this back on the screen. We talked about our fees and that we're going to not be offering payment plans. If you really need a payment plan, we will give one to you, but we're not going to take on cases that need payment plans until after the month of September is over. So if you want to wait until October, we will let you do a payment plan, but we're not, that initial rush wave of filing, we're taking all the money up front, okay? And I think that's fair, guys, right? I'm always a very fair person with you guys, but one of the things I'm very good at is case management, and And I think most of you agree that like you never wait too long for us to finish your filings and get them filed for you. And that takes a lot of organization and coordination on our part, right? And we have really thought this through a lot about how when August 19th hits, how we are going to get these done as quickly as we possibly can, okay? So documents needed. This one's easy. Identification. Make sure you have a valid passport, or some of you may have a driver's license. I don't know how, but because most of you don't have status, but it's listed there. Okay. Proof of the marriage. We obviously have a lot of these documents for you guys. I still think it would be nice if you sent them to us again, just so we're not like searching through the old files, just so we can work with you faster. But in theory, we should have all of these. If you're an existing client, of course. Copy of your marriage certificate executed prior to June 17th, spouse's proof of citizenship, and copies of divorce and death certificates for prior spouses, right, to prove that legally valid marriage, right? Now, evidence of physical presence from at least June 2014 to June 2024. Now, this is really important. The evidence must be provided for each year. You can't skip a year, right? There's other case types that require physical presence, U visa, adjustments, cancellation of removal in deportation proceedings, has a 10-year physical presence requirement. And they take these things really, really, really seriously, okay? And so we are going to need a document from each year. You cannot skip a year. Ideally, I would love a document from each month or each quarter of each year, right? That would be the ideal. Like when I do cancellation or removal in court, I do a document of physical presence for each month of each year of the 10 years, right? That's obviously asking you guys a lot. Minimum each year. Great if you can do something from each quarter of each year. If not, at least each month of each year, even better, but at least each year, guys, okay? And yes, it's a lot, okay? But it's super important. We have to, they don't know when you got here. I mean, obviously, we've indicated on your I-61A form, your date of entry. So there is some sort of at least record in USCIS for those with I-61A pending of when you entered, but or if you have an I-130 pending right now or an I-130 approval, would have been on there. But other than your word on those forms, there is no actual evidence of your date of entry. So this is something that we have to take very seriously. Okay, so examples of evidence. Obviously, U.S. tax returns are the best. If you've been filing taxes under an ITIN number or you had an existing Social Security number, I'd love your 10 years of tax returns, please, from 2020. From 2014 until 2023. Okay, obviously you're not gonna have a 2024 tax return. Okay, yeah, okay. Monthly bank statements. Bank statements are great. Even a letter from the bank saying when you open the account in the United States, obviously if your bank goes back really far, you're probably not gonna get monthly bank statements going back more than a few years. But for the most recent years, we can use monthly bank statements, right? And I want to just highlight this part here. We need documents with the applicant's name, the date of the document, and showing that you're in the US, right? Like, so it needs to be something that shows you are also in the US, right? Some of you guys get like your bank statements in Spanish and things like that. You should try to pull English versions. We'll try to submit them without translations, but remember, if something's not in English, you will need a translation. Lease and rental agreements are another great proof. So, you know, if you can go back through your history and pull all your old lease and rental agreements for where you've been living over the past 10 years, those are great evidence, right? Car registrations, if you had cars, car insurance, deeds and mortgages for properties, if you own properties here, car purchase and lease agreements, right? Utility bills, cell phone bills, school records for the applicant. Applicant's child we can use, but technically your child could be here without you. So I don't know if that's 100% proof that you were actually here, just your child's school records, maybe paired with the records that show like you were the person like enrolling the kid in school would help. But obviously if you went to school yourself at all, high school, college, English classes, vocational courses, certificates, any of that can help show your presence in the United States. Hospital and medical records, rental receipts, money order receipts for money sent out of the United States, right? So like if you've been sending money back to your family in Mexico, like often Western Union can give you a whole printout of all of those transactions, and it shows you're here and you were sending the money over to Mexico, and it'll say sender's name, you know, receiver's name. Those are great records. Obviously, if kids born here, the birth certificate is showing your kids being born here with your name on the birth certificate, right? license, titles, registrations. That one kind of similar to the car registration one, but try to be thorough, guys. Insurance policies, car insurance, health insurance cards, anything like that. Pay stubs, W-2 and 1099 forms for each year. Social Security earning statements. If you do have a Social Security number, you can go online into a Social Security account. It will show you all the earnings that you've made in the United States. Records from religious entities, right? So like a baptism certificates, consecration certificates, showing that letter from your church, right? Union, other organizations. Letters are going to be the weakest evidence, guys, right? Obviously, if we don't have other evidence, like we'll get notarized letters. But just remember, letters are always going to be considered the weakest evidence. We really want objective evidence with your name, the date, and showing that you were in the United States for each one of those years: 2014, 2015, 2016, 2017, 2018, 2019, 2020, 2021, 2022, 2023, 2024. I want to make this very clear. Each year. Okay, guys, please. Okay. If you want to, this is, I'm not gonna make people do this, but if you want to get a police clearance letter from your jurisdiction showing that you have no arrest history, I think that's great for that prong that says you have no disqualifying criminal history. All right. Positive discretionary evidence, right? So now we're going to switch to discretionary evidence, right? They're going to look at the case by basis, not an automatic approval. We want to show that in discretion, we merit this, right? Now, examples of positive discretion: all your family ties in the US. So we want copies of the green cards or US passports, certificates of naturalization, birth certificates for immediate and extended relatives in the US. So if your brother's here in status, your mom's here in status, your aunt's here in status, like let's put all of that in. We want to show all of your family ties in the US. It's a very important factor in positive discretion. Evidence of any prior or current lawful status in the U.S. So if you ever had DACA, TPS, you applied for asylum, you had a visa at some point, we want to see all of that to prove it. Most of you guys are not going to have like extension receipts, things like that, because you entered without inspection, right? Pursuit of education in the U.S., any U.S. diplomas, transcripts. This is both for discretion and for physical presence, right? But obviously, some of you guys will have gone to school way more than before the 10 years, right? So if you went to school in the U.S. in 1999, you graduated here, I want to see those transcripts. I want to see those diplomas. Vocational courses, like I said, anything like that. You became an AC tech repairman, like I want to see your AC certificate. Any professional licenses. Let me actually add that. So you guys are helping me even make this better. Professional licenses, vocational certificates. Okay, all right. Always improving, guys. Always improving. Okay, now, this is just always something we add for discretion. Obviously, if any U.S. family members in the U.S. military, we want to put all that in, right? Ties and contributions to the community. Do you volunteer? Do you go to church? Do you own a business? Are you part of the Rotary Club? Whatever. Like, we want to show that you are good standing members of your community, right? If you are the primary caretaker for anyone with a mental or physical disability, serious illness, a minor child, we want to have all those medical records. We want to have letters showing that. We want to show you are hardworking and employed in the U.S. if that applies to you. So you want your pay stubs, an employment letter, any employment benefits, retirement, life insurance, your business and corporation documents, showing that you're a good person, right? That you're hardworking, not going to be a drain on the U.S., you merit discretion, right? Property ties in the U.S., deeds, titles for homes and vehicles, boats too. You're guys in Florida, a lot of you boats, mortgage statements, homestead exemptions, any property ties you have in the U.S. This kind of is similar, but evidence that you're the applicant themselves or the applicant's spouse suffers from mental or physical illness. So that's again medical records, therapist letters, IEP records for children if your child is in a special needs program. Psych evaluations, insurance cards, prescriptions, or recent prescriptions. We want to put all of that in. So that's kind of our list of our discretionary evidence, right? So like I said, you guys got all that emailed. I want you all to start working on gathering that evidence. Most of us are going to be working together remotely. And so you want to start like taking the pictures, PDFing these documents so that you can send them all to us. Get yourself a folder together, a digital folder together of all your evidence so that you can send it to us as soon as you hire us, so we can start working on the case right away. Okay. Now, speaking of that, how we process the cases, I want to be as fair as possible to all you guys. So we will process the cases in the order we receive the payments and the evidence, right? So if you pay me, but you give me no evidence, I'm not working on your case. If you give me evidence, but you give me no payment, I'm not working on your case. If I have both your payment and your evidence, then we're going to start working on your case in the order of receipt, like the last thing that we were given, like if you to complete both payment and evidence, right? And that, just to be fair, that's exactly what we're going to do. And like I said, we're very good at time management, me and Miriam. We've talked about this a lot, how we're going to get this all done. And we have a plan, okay, guys? But just know, like, if you give us one and the other, we are not going to be working on your file, right? If you give us both, we will put you in line for actual casework, and we will do that in the order of last receipt, okay, of one of the two, payment or evidence. That makes sense, okay? Now, the last things I want to talk about before I get into the disqualifying issues is what happens after that, right? So we're going to file our request per our instructions, which are going to come on August 19th. We'll figure out where we file it, what form, we'll get those forms up to you to sign. And then we will get in line for the parole, right? Now, if we get our parole, what will happen then is the best news, we will then file for our adjustment of status. Now, paroles also allow people to get work authorization, right? Now, obviously, I will leave this up to you guys to decide, but it's going to be my opinion and advice that we don't file for a parole necessarily under the parole case, and that we just file for a parole under the green card case, right? So all people that have pending adjustment of status in the U.S. are entitled to ask for a work permit, right? That's a different code for the work permit than it would be for a parole work permit. Now, why am I saying that? Again, I'm always practical with you guys. I'm always thinking about you and your pockets because I want someone to think about my pocket. When the current fee for a work permit is $520, right? That would be the fee for a work permit based on the parole program, right? And again, these are all going to be additional services. That $3,000 fee is just for the parole program. I want to be very clear about that. If we're going to do a work permit afterwards, if we're going to do an adjustment afterwards, these are all going to be separate things that you will have to budget and save for accordingly, okay? This is just the parole program, right? Now, I was saying that a parole employment authorization costs $520, right? It's a normal full work permit fee. The work permit fee under a green card case is $260. It's half, right? And that's because it's going in concurrently alongside of a green card application. So as soon as we get that parole issued, we can start working on your adjustment of status right away. Why would we wait? Most of you have approved I-130s already, right? There's no reason to wait. So if we're going to do that paperwork anyways, we're going to do the adjustment of status, we can file for a work permit under the adjustment status. Why not save that $260 and get the discounted work permit under the adjustment of status case instead of doing the parole one? Now, if you, for some reason, want to delay your adjustment of status, you just want to get the work permit under the parole, of course, we will do that for you guys. But it's going to be our recommendation generally that let's just do the adjustment, get the work permit on the discounted rate, the half price rate under the adjustment, save you guys some money. Since all of this is going to be expensive, guys, I'm not gonna lie, all this is expensive each step, right? And so where we can save money, let's try to save money, right? Okay, now, so that's what work permits. You can't get a work permit until the parole is issued because you need the parole to apply for that work permit, or you'll apply for the work permit under the adjustment of status. So work permits are not going to come until you get the parole. You can't even apply for a work permit until you get the parole, whether it's under the parole or under the adjustment of status. And then, of course, like I was saying, the whole name of this game is to get the parole to do adjustment of status. And just note, I mean, I don't know, but generally, if you have an approved I-130, we're just doing the adjustment of status legal work. We're probably going to charge around $2,000 in legal fees for that, maybe $2,500 in legal fees. But the filing fee for an adjustment of status right now is $1,440. And like I said, most of you are going to apply for a work permit, which will be another $260. So I want you guys to be budgeting for the second step, which is going to be that adjustment of status, which if we're charging around $2,000, the government fees are going to be like $1,900. Oh no, I'm bad at math, like $1,800. So they're going to cost almost the same amount of government fees that it will in lawyers' fees to do that adjustment of status later on. Okay. But I want you guys also, after we file these paroles, to start saving up your money for your adjustment of status process. Okay. I'm going to assume that you're going to get your parole and that we're going to move forward with the adjustment afterwards. Okay. So please know that. Now, right now we don't anticipate any reason why you can't do this with your I-601A waiver pending, right? You also, there's no reason why you can't do it if you haven't started the I-130 marriage process, right? Like there's nothing in this that says you need an I-130, right? So you can, in theory, like some of you have hired us to do the I-130 process. We haven't filed it yet, or we filed it, it's pending. We can go ahead with the parole process, and then as soon as you get the parole, we can file for adjustment of status. And for those who haven't even started with the I-130, we can wait and get the parole first and then do the I-130 concurrently with the adjustment of status like we do for people who have entered with visas, right? So it doesn't matter that your waiver's pending. It doesn't matter that if you have filed an I-130, if you haven't filed an I-130, we can still do this program, and we should do it. So like I said, that we don't get stuck in the back of the line for this program, okay? Now, I think that was part of it, pretty much what I wanted to cover with you all regarding the basics of the evidence, the program, the pricing, and kind of how we're going to work in the office. Now, this rest of the part of the video I told you I would tell you is going to be about the disqualifications, right? So if you don't fall into any of these, you really don't need to be watching the rest of this video, right? So removal orders, people with removal orders, people with pending removal proceedings. Okay, I want to talk to you guys. Okay, it's not, I have doubts that you are going to qualify for this program, and I want to explain why. Right now, as I told you, that parole in place exists for military families right now, right? Now, if you have a removal order, you can get a parole in place, but it is not USCIS that issues those parole in place. There's a jurisdictional change, and the paroles are issued by ICE. And I've never tried to get a parole in place, military parole in place through ICE for someone with a removal order, but I know colleagues who have, and they say it's almost impossible. Okay, so it's like I said, it's a jurisdictional issue, right? Just there's no jurisdiction at USCIS to give paroles in place to people who have removal orders or who are in removal proceedings. Now, if you're in removal proceedings, we could probably try to dismiss them because they're ongoing, saying, hey, you're eligible for parole in place, and maybe that would work. I can't guarantee that, but you're not going to just jump right into the parole program. Like it's either dismissing an existing proceeding, reopening an existing proceeding, or waiting to see if there's a procedure through ICE. Or, I mean, again, they haven't published the final rule yet. Maybe the final rule will say you guys do qualify. We'll say that it's okay to have a removal order. But like I said, historically, the existing parole in place programs that we have for the military do not allow for a parole in place request with USCIS for people with removal orders. So again, I have serious doubts. I will not know until after August 19th. And I will update you guys on this issue after we get the rule. On day one of the rule, I'm going to examine it, but then I'm probably going to wait a few days to speak with other immigration lawyers, wait, for example, for the American Immigration Lawyers Association to send out practice advisories. Like there's people whose jobs it is, like I'm a member of the American Immigration Lawyers that pay big membership dues, and they have a team there that of immigration lawyers who do exactly this, dissect these new laws for us, and then publish practice advisories telling us like this is what everything means, right? So I'm going to be waiting for those to be issued. We do my own analysis, of course, right when it comes out, but kind of waiting for the consensus among immigration attorneys about whether or not we believe people with removal orders will be able to apply. So if you have a removal order, you can still gather your evidence, save up your money, but I will not be taking your case on August 19th. We have to figure out if you actually qualify, okay? Now, the next group of people is multiple and illegal entries, right? Again, multiple illegal entries. This is something we call the permanent bar. We call it the permanent bar because you can only do a waiver after you've been outside of the United States for at least 10 years, right? So nobody does that usually voluntarily. So we call it a permanent bar, even though it's technically not permanent. You can apply for a waiver after 10 years abroad, right? Now, these are for people multiple legal entries after April 1st of the year 1997, okay? Or at least the last entry has to be after April 1st of 1997. Okay, now, there's a question. Will you guys qualify for the program? I don't know. They may just put in the rule itself, you don't qualify, right? If they don't put in the rule that you don't qualify, you may still be able to apply. However, like I said, there was that wording about you have to be otherwise eligible for adjustment of status. That could just say no, not otherwise eligible for adjustment of status because you're inadmissible under the permanent bar under Section 29AC of the Immigration Nationality Act. Or they may grant the parole, which could happen. So, for example, in the cases of, it's the only reference we really have, guys, is the military parole in place program that exists. With military parole in place, they do sometimes give paroles out in discretion. Again, they could just say no discretion. They could say, nope, going to exercise negative discretion against you because you entered the U.S. multiple times illegally, right? So that's a valid, fair point of view from USS that they're just going to exercise negative discretion in these cases too. So they may say you qualify, but in our discretion, we're saying no because of the multiple illegal entries, right? The other thing that could happen, like I said, is that there are military parole in place cases that do get approved with multiple illegal entries, but they are those that still does not cure the adjustment of status issue, right? So like for everybody else, it's going to cure the illegal entry so that they qualify for adjustment of status. For people subject to the permanent bar, multiple illegal entries, the parole will not change the multiple illegal entries. You're still inadmissible under that ground. You will never get to adjustment of status with that. Without spending the 10 years abroad in the waiver, you will never get to adjustment of status in the US. And so it's a possibility that you may be able to do the parole, but then not go on to the adjustment of status step. Now you'll have to weigh, do I want to try it? See if you get the parole. Nowadays, in most of the parole programs are issued in 2-year increments. You could have a 2-year work permit under that parole, right? So maybe it's still worth it to you, but you also have to think about the risk of if you've entered the US multiple times illegally and nobody knows where you are, you've never given your information to immigration, because you're different. Like all my I-601As, you guys already have your information with immigration, or you have your I-130s filed, you already have your information with immigration. You really don't have anything to lose by giving them more information, right? But for those of you who immigration has no idea you're here, and you are subject to that permanent bar, you're going to have to think about whether or not you want to provide all your information to immigration in case you get denied, and especially if Trump becomes the president in November, right? And so you guys have a lot more to think about, even if on the face of the program you still qualify. It's not going to get you adjustment of status. It's not going to get you your green card in the U.S., but maybe you could get the parole issued and then have your work permit during that parole time, and maybe there'll be what we call a re-parole, where you can, keep on renewing those paroles and keep on getting work permits, right? So it could benefit you, it could not benefit you. Again, it's still a little bit of a gray area. We will not be taking cases on August 19th with multiple legal entries. We will need to read the rule. We'll need to read the analysis, the practice advisories, and then we will let you guys know the risk, or if you qualify, and if you do qualify, the risk, obviously, of applying in your particular circumstance, right? The last ones are the criminal records. Like I said, if it's an inadmissible criminal record, you may be denied on discretion just because you're inadmissible and you're not otherwise eligible for adjustment. And then obviously we have to wait until August 19th to see the actual criminal disqualifiers. And then we'd have to analyze, right? So if you have a criminal record outside of traffic, again, not talking about traffic, not talking about driver's license related, things like that, then you need to get certified copies of your criminal records, and you would need to send them to me or have a consultation with me so we can analyze, once we know exactly the criminal disqualifiers, whether or not you continue to qualify, okay? I think I did it all. Guys. I really wanted to get this done before I go on my trip. I'm literally gonna be posting these videos and then packing, okay? And so like I said, on August 19th, we will, if you want to do the case, let us know. We will send you a secured payment link so you can make a payment online to start the case. And then you will start sending us over our documents and we will start working right away. Okay. All right, guys. I'm so happy for you. Those of you who qualify, this is going to be such an amazing program for you. And we so look forward to helping you with these cases. Thanks, guys. Bye.